Okay, first we start with the introduction. The basic human right to freedom of peaceful assembly must be given due recognition and can only be restricted by law of the purpose of preserving national security or public order. In Malaysia, the right to assembly peacefully and without arm is provided for by the Federal Constitution under Article 10(1)(b). This is, however, subject to restriction imposed by the law which Parliament deems necessary or independent in the interest of national security of public order in Article 10(2)(b). It is clear that every citizen has rights to assemble peacefully even though we are subject to certain restraint given under the law. Unlawful assembly generally means a meeting of three or more people likely to cause breach of peace or to endanger public. This is also a legal term used to describe a group of people with the mutual intent of deliberate disturbance of the peace. According to Lord Hawkins, unlawful assembly is not only the assembly to do an act which is if done will make turbulence, but if the meeting of many people which will endanger the public peace in order to recover their interests. Alright, next I am going to elaborate about application of law on right to assembly and the restrictions before 2012. Okay, the first is constitutional right and restriction. Article 10(1)(b) of the Federal Constitution provides that all citizens have the rights to assembly peaceable and without arms. It is important to note that having stated that, the article permits Parliament to impose restrictions on freedom of assembly on grounds of security and order. Article 10(2)(b) of the Federal Constitution provides that the previous piece, the Federal Constitution permits Parliament to impose restrictions on freedom of assembly on ground of security and public order even if violate certain rights under Article 149 of the Federal Constitution. The next is Penal Code. In accordance with Section 141 of the Penal Code, participants in a private, public, or private gathering can amount to an unlawful assembly if the gathering of five or more persons has the common object of intimidating. It can be said that the members of the assembly who would like to have the common objective during the assembly will be jointly liable for the offense committed. Okay, the next is Internal Security Act. Section 3 of the Internal Security Act empowers the Home Minister to prohibit organization and association of a politic or military character. The implication of this section are that once prohibited, an organization is incapacitated from applying for a license to hold an assembly or procession. Moreover, the Security Offence Special Measures Act 2012 SOSMA has replaced ISA. According to Section 4 of the SOSMA, a police officer may without warrant arrest and detain any person whom he has reason to believe to be involved in security offence, and the person arrested may be detained for a period of 24 hours for investigation. A police officer of or above the rank of superintendent of police may extend the period of detention for a period of not more than 28 days for the purpose of investigation. Societies Act 1966. It is important to note that this act could also be used to curtail or restrict freedom of assembly. For illustration, this act prescribes procedure and conditions for the registration of the societies, punishment for managing unregistered societies, and confer wide powers on the minister to clarify societies. As provided under Section 2, any club, company, partnership, or association of 7 or more persons, whatever its nature or object, is deemed to be a society, and it is an offence for the society and its members to take part in any organized activity without any written permission of the registered. The society is properly registered. Police Act 1967. The Police Act confers wide discretionary power to the police to regulate assemblies, meetings, and processions in private and public place. Section 26. It empowers the police to erect barriers in any place in order to control the movement of persons or vehicles. Section 30 permits the regulation of flags, banners, placards, and loudspeakers in order to prevent the disturbance of peace. Section 27 2. All assemblies, meetings, and procession or more than 3 persons in any public place require a prior license from the officer in charge of the police district. The license must be applied for by a registered organization or by 3 organizers jointly. An application must be made 14 days in advance. The license must assume responsibility for the entire conduct of the rally and its component members. Section 27(5). If 3 or more participants of an assembly or procession disobey by any of police order, the entire assembly shall be deemed to be an unlawful assembly, and all the person taking part knowingly in the assembly shall be deemed to be an unlawful assembly, be guilty of a criminal offence.
My name is Sakina Azabinti Abdurrahim, metric ID 420-1003151. I'll be continuing with the recent developments in the freedom of assembly. Previously, in Section 2 of the Police Act 1967, the right to assemble had been cemented in the catch-all. The provision stipulates that all public assemblies or processions that involves more than 3 persons has to obtain in advance a license from the OCPD. The granting of it was discretionary and often was denied or it was accompanied by a set of restrictions. However, the relevant section in the Police Act has been repealed by the Police Amendment Act 2012. On the very same day, the Peaceful Assembly Act 2012 replaced it as the principal legislation dealing with public gatherings. This means that permits from police to organize and assemble will no longer be needed. Instead, the new procedure is that the organizers must notify the OCPD within 10 days before the gathering date, and they shall respond back within 5 days with an outline of the restrictions and conditions imposed. If they fail to respond, the assembly may proceed as proposed. Any person who breaches the proposal shall be liable to a fine of not more than 10,000 Malaysian ringgit. They can also appeal the restrictions within 48 hours after the announcement of restrictions to the minister. Section 2 of the Peaceful Assembly Act provides the people to hold and participate in assemblies within a harmonious manner without involving armaments. Such assemblies include wedding receptions, funeral processions, open houses during festivals, religious assemblies, family gatherings, and the likes. All this are done in consideration so that a person may exercise the right to participate on peaceful assemblies while free from unreasonable restrictions. This represented a chance for a right to organize and take part in such assemblies, but still subjected to certain restrictions under the Act. On the other hand, the street protests that consist of mass marches or rallies are not permitted. Under Section 4, Subsection 1 of the Peaceful Assemblies Act, it states that the right to assemble is not inclusive to street protests. Therefore, by virtue of the act, it is considered illegal. Thank you.
Next, I'm going to talk about challenges faced in the area. So, despite the fact that peaceful assembly is enshrined in the Universal Declaration of Human Rights and Article 10 of the Federal Constitution, prosecution has been attempted to prosecute of or intimidate people from exercising their rights to freedom of their expressing and peaceful assembly. Activists are being charged. Police suppressed freedom of assembly and arrest were made during each demonstration. In a sense, not all experience has been positive. When it comes to guaranteeing rights to assembly, governance, laws and practice are more restrictive in Malaysia. On the federal surface the constitutions seem to provide guarantees, but it is important to note that at the same time it also includes limitations on grounds of national security, integrity of the country, public order, and public moral. In fact, these limitations have been translated into laws on national security, criminal defamation, sedition, and anti terrorism that restrict assembly and association. Throughout the year, there were examples of the authorities using PAA to restrict the right of assembly. Many of these incidents were connected to the electoral process in a year of general election. The gathering that is now known as Bersih 3.0 hit international headlines mainly for the heavy-handedness of the authorities in dealing with it. Violence by the authorities against those assembled and the many untoward incidents witnessed during Bersih 3.0 are a matter of public record. It was therefore with some optimism that it was observed that in dealing with the Himpunan Kebangkitan Rakyat gathering KL112 on 12 January 2013, the authorities adopted a much more professional approach. This allowed the gathering to take place peacefully and without incident. The accommodative approach demonstrated by the Royal Malaysian Police was a positive change and appeared to get the year of the promising start for the exercise of the right of freedom of assembly. However, this hope was short-lived. The police subsequently announced that they would investigate participants of the KL112 for alleged violence of the Peaceful Assembly Act 2012. On 30th January, the police launched a search for 14 individuals who had allegedly brought children to the Himpunan Kebangkitan Rakyat rally. The police released photos of 14 people which were posted on the Kuala Lumpur's police Facebook page. The news article stated that the act of taking children to rally at Stadium Merdeka contravened Section 4, Clause 2 of the Peaceful Assembly Act 2012 and Section 331, Clause 1, Clause A of the Child Act 2001. These cases highlighted the many shortcomings of the PAA. As pointed out by Swaram in their Human Rights Report 2013, the imposition of the requirement to fulfill the 10-day prior notification procedure and the arbitrariness of prosecution indicate the PAA 2012 and associated legislations related to freedom of assembly has been used by the government against political opponents and civil society protests. The fact is that many gatherings and rallies took place almost immediately after GE13 as the public mobilized to voice dissatisfaction over the claims of electoral irregularities and voting abuses. The PAA was with its 10-day notification window is clearly unreasonable and effectively denies spontaneous peaceful assemblies where citizens gives peaceful voice to a current topic of public concern.
Okay, freedom of assembly. With all that being said, a proposition could be made to impose a statutory obligation on the police and government to promote freedom of assembly. For example,
in Finland, the government is required to promote the exercise of freedom of assembly by protecting the right to assemble without hindrance and by providing the necessities of the assembly. And the police is under a duty to safeguard the exercise of freedom of assembly. Not only that, they can also remove the prohibition on the participation of children, as it can be contrary to the international obligations under the Convention of the Rights of the Child (CRC), which Malaysia agreed to in 1995. On June 6, 2010, Malaysia withdrew its reservations to articles of the CRC, therefore allowing children the freedom to have their say and the right to form associations and assembly peacefully. Okay. From this, I can conclude that the decision maker must understand correctly the law that regulates its restriction and must not transgress the express or implied limits that surround the statutory grant of power. Power should be used, not abused, and the recipient of power must act fairly, rationally, and in good faith. There shall be a fine line between power and government in restricting freedom of assembly and how much right of citizens to assemble should be given. Without freedom of assembly, there could be no political dialogue, no criticism of government, or even freedom to debate. The freedom to assemble should not be unlimited. There has to be some sort of legal restrictions that ensures the exercise of rights to assemble peaceably and without arms. Thank you.